Justice of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business before this court will draw near, give their attendance, and they shall hear.
Thank you. Please be seated. First case that we're going to hear argument on is Durkee versus Sanchez Rodriguez. That's case 493. Both lawyers are remote. We have Mr. Kaiser there and Ms. Waterman. Mr. Kaiser, you may begin.
Good morning, Your Honors. Matt Kaiser for the appellant respondent, Charles Durkee. It's our position that the court below erred when it denied our motion for summary judgment on the issues of negligence and liability. And in this case, it's really undisputed that defendants violated multiple provisions of the vehicle and traffic law, which, as this court knows, supplies the duty of care in these sort of cases. We have a farm tractor towing an oversized manure spreader, and that is happening more than 30 minutes after sunset on a cloudy November evening. This oversized manure spreader has large beaters that extend upward, and based on all the photographic evidence in the record, they would fully obscure the farm tractor. And so we have two provisions of the VTL that defendants do not dispute they violated. We have VTL 375-2A3, which is known as insufficient tail light, and it requires a lamp on the rear of a vehicle that is visible for at least 1,000 feet. And of course, if this tractor stands between our client and the manure spreader stands between our client and the tractor, it's not going to be visible.
Mr. Kaiser, could I stop you there and ask you this? Yes. There's, at least in my mind, there can be no reasonable dispute that the defendant was negligent.
Correct.
The issue seems to be proximate cause and comparative fault. The expert for the defendant, as you know, his theory is that your client, if they were on a level road, your client wouldn't be able to, there would be no lights visible on the tractor for your client. But right. The expert says it was a hill, he was on a hill, and given his position, he could look down and see the lights on top of the tractor that he wouldn't have been able to see if he was directly behind. And therefore, he should have seen those lights and slowed down and avoided this collision. That seems to be their only defense here. How are they wrong that doesn't raise an issue of fact, at least on proximate cause?
And so our position is that opinion is speculative and conclusory. Lacking from that opinion is any mention of human reaction time, any mention of the fact that, and really what their expert is saying is that our client should have seen the lighting on the rear of the tractor. Their expert does not assert that there's any lighting on the rear of a manure spreader or that there's this retroreflective emblem, which is supposed to be there. But of course, if the manure spreader, which is dark, it's a manure spreader, is standing between any alleged lighting on the tractor and our client, it's not going to be visible. It's not displayed as required by the statute. And also, and kind of to your Honor's question about the gradient of the roadway and the fact that this is a slight downhill, there's no analysis whatsoever as far as the gradient of this roadway. There's no demonstration by this expert that this would have been actually visible to our client. And so I think all the arguments made by the defendants and really as encapsulated by the opinion of their expert is that this is an issue of comparative fault. There was a case between from the third department in 2018 involving a bowl in the road. Defendants maintained that it would have been visible and that the plaintiff should have avoided it, and therefore there could not be a finding of negligence. The third department reversed that and said, that's an issue of comparative fault. And that's really our position here today. We didn't move to strike that affirmative defense. We're not conceding there is a comparative fault.
Right. You want liability under Rodriguez, let comparative fault be resolved later. What about serious injury? There's a question here of whether that statute even applies. And it seems to turn on whether the tractor and the spreader were used exclusively for farming purposes. You make a good case that the manure spreader was used for agriculture only. But what about the tractor? Did you establish as a matter of law that the tractor itself, as opposed to the spreader, was used exclusively for agricultural purposes?
Yeah. So, I mean, if you look at at the evidence of the record and looking at page 301, Mr. Sanchez Rodriguez, who was the operator of the tractor towing this manure spreader, was, quote, either on the loader or a tractor most of the time. His primary duty was to, quote, clean up manure and put it in the manure spreader. And on the date of incident, the farm tractor was towing that manure spreader. There's no evidence in the record that either the tractor or the manure spreader were used for anything but agricultural purposes. In fact, the only evidence in the record is that this tractor was used exclusively to tow this manure spreader. So based on that unrebutted evidence, we feel we established, similar to Graham v. Giro from 2015, which I think Your Honor was on that panel. This is a tractor and a manure spreader that's used exclusively for agricultural purposes. It's therefore not a motor vehicle. And because the defendants have not demonstrated that they're covered persons, the serious injury threshold should not be any impediment to a finding of liability.
You may be right, I don't know, but why your client had a fracture on the arm, and why are we even talking? That's a serious injury right there, amongst other injuries he had. Why do we need to even resolve this if you got a fracture?
Right, and we don't feel we need to demonstrate that. I think we could have demonstrated that. And I think the case law is clear that an issue that hasn't been raised on a previous summary judgment motion can be raised on a subsequent motion if necessary. But we are confident based on our position. We relied on Graham v. Giro from this court from 2015, and we looked at all the evidence in this record, and we saw that there is no evidence that this farm tractor.
Yeah, I mean, maybe you're putting all your eggs in that one basket when you have a basket that has a lot of eggs in it already with a fracture. And then once you have one serious injury, you get all your injuries into the jury. But we will take a close look at that issue.
Thank you, Your Honors. Unless the court has any questions, that's the essence of our position.
I had one question, back to proximate cause, following up on Justice Lindley's questioning. This accident occurred over the crest of a hill, right?
It happened after the crest of the hill.
Right, but the plaintiff familiar with the roadway, correct?
Correct.
So he's familiar with there's a crest of the hill, and then as I'm approaching that hill, I'm not gonna be able to see what's on the other side. And my understanding is that this accident occurred shortly thereafter, him getting over the crest of the hill. I think that was the plaintiff's own testimony in his deposition, correct? That he's familiar with it, the crest of the hill. I can't see what's over on the other side because of this crest. So didn't basically the plaintiff then create a question of fact on whether or not that was the proximate cause was only the fact that the manure trailer wasn't lighted and didn't have the reflective features?
I think at best, it would create a question of fact as to culpable conduct or alleged culpable conduct compared to fault on the part of the plaintiff for not seeing what's there to be seen. But based on the evidence, it wasn't there to be seen because it was fully obscured by this dark manure spreader. I mean, if you look at this, the cases from this court.
Well, I think it seemed as though the plaintiff was saying, I wouldn't have seen it anyways. There's a crest, there's this crest. I wouldn't have been able to see it as I approached the top of the crest of the hill anyways.
I don't believe that's true, Your Honor, because it was, I believe their experts said it was about 500 feet from the crest of this hill to where the accident happened. And if you look at, I mean, really, someone traveling at night on a country road in the dark is going to expect other vehicles on the road to be illuminated, to be visible. That's, I think, an ordinary expectation. So I think that we have established an inference of negligence that was unrebutted. And I mean, all these arguments, all the points that Your Honors are making, I think it goes to comparative fault, which is still in this case. So that's the essence of our opinion.
But don't we have a valid experts here too?
Well, we have, in our opinion, we have a speculative.
I know you don't like the defendant's experts testimony or report.
Well, you should like the defendant's experts testimony.
Okay, thank you.
Thank you, Your Honors.
Ms. Waterman, you need to unmute and then you may begin.
May it please the court, Tara Waterman. I have only requested 5 minutes to argue. I would start by asking if there's any particular points you want me to address right now.
Would you concede there's negligence by your client? Not proximate cause, not liability, not but just negligence, driving a tractor in the dark with a spreader, with no lights on the spreader, no reflective signs at night, going no more than 18 miles an hour on a road where the speed limit's 55. Would you give us that much that that's negligent?
Yes, Your Honor.
Thank you.
The
So then-
issue, go ahead.
So proximate cause, you say there's an issue of fact regarding comparative fault. He should have seen the tractor when he was up high, the plaintiff. And therefore, your client's negligence might not have been a proximate cause. The sole proximate cause would have been the plaintiff's comparative fault. That's your argument, right?
It is my argument, Your Honor. I would just modify it slightly and say that we're talking about, my expert says the sole proximate cause was the plaintiff's inattention, which is, it's our position that that raises an issue of fact as to the first two questions to establish liability. Was the defendant negligent? You know, certainly I don't have the authority to concede that on behalf of my client, but for
I
purposes
thought
of
you
this,
just did. Okay.
I know. Well, for purposes of this though, I'm not
All
going
right.
to
We'll act like we didn't hear it.
I'm not going to ruin my credibility by arguing that point. But in terms of proximate causation, when the plaintiff has the burden to demonstrate negligence and proximate causation, looking at the moving papers before the court, which are in the record at 21 to 31, the plaintiff did not do that. Now the plaintiff asked the court to infer causation from the VTL violation, and I understand that. But we have raised an issue of fact with our expert, which says, Mr. Scalia opines that the tractor and the manure spreader were sufficiently illuminated given the tractor headlights, the headlights of the vehicle coming in the other direction, as well as the plaintiff's headlights. He also opines that after plaintiff crested that hill, there was sufficient time to observe it and avoid the accident. He says in his affidavit that the sole cause of the accident is plaintiff's inattention. So in that sense, then we've raised an issue of fact as to proximate causation, and a finding of liability under Rodriguez is not appropriate.
But doesn't your expert support the plaintiff's side by saying there was enough time for her to see? Had the lights been on, then she would have seen it. Just listening to your expert.
Well, the plaintiff testified that he crested that hill and then bam, the accident happened. I think he said he saw it within 2 seconds of the impact. My expert's saying there's more to it than that. The distance over the hill is longer than the plaintiff recalls as well. And because that's longer, the manure spreader was visible to the plaintiff.
The manure spreader didn't have any lights or reflective signs. I think the expert said that the tractor lights, the tractor apparently had some, there were tail lights which would be totally obscured, but there were lights on top of the tractor, as I understand it, that were about the same height as the spreader. So the plaintiff, if he were paying close attention, I guess when he was up higher, could have seen these lights and slowed down. Your experts suggest either the plaintiff must have been speeding or just daydreaming, looking out, not watching where he was going. That's his explanation. And that's his theory, I guess.
Yes.
Serious injury, do you want to be heard on that?
Just briefly, again, Your Honor, looking at the moving papers, the plaintiff put in one paragraph that said, we don't have to show serious injury. In Graham versus Jurau, which was this court, the defendant didn't oppose that. I don't know why, but in our case, we did oppose it. And we said we actually cross-moved, because we said first, the issue is not necessarily whether the tractor is considered a motor vehicle, but under 5102 and 5104, the issue is whether the defendant is a covered vehicle. And because the defendant had minimum financial security in effect at the time of the accident as required by New York State, the tractor was insured by a liability policy. It is a covered person. So we don't have a situation where serious injury would not apply. in the alternative, plaintiff in his reply and opposition papers to our motion addressed the issue of whether the tractor was used exclusively for agricultural purposes. However, that was not addressed. There was no affirmative prima facie showing as movement for summary judgment in the first place on that issue. And
If he did meet the burden, would you agree that the spreader was used only for agricultural purposes?
No, I would not agree that.
What non-agricultural purpose would be spreading manure everywhere?
That's a logical question, and I think that it can be addressed, but it was not addressed by plaintiff in the prima facie showing. In terms of our response, we said we are a covered person.
Right.
And you didn't.
I'm just saying, like, what conceivable non-agricultural way would you use a manure spreader?
Well, Your Honor, I think there is a question sometimes whether, under some case law, whether the mere virtue of the fact that farm equipment even enters the roadway raises a question of fact as to whether it's used exclusively for agricultural purposes. That's what I have to offer.
Counsel, I just have one question on the issue of vicarious liability.
Yes.
Why would your client not be vicariously liable for their employee who is in the course of his employment?
Your Honor, I am reaching here, but I don't recall us opposing that part. I don't recall us opposing vicarious liability.
Okay, if you didn't oppose it, that's fine.
Right, thank you, counsel. Case 480 is People versus Gamble. The appellant has submitted. The people are here. Good morning, counsel.
Morning, Amy Wallensack on behalf of the people. In light of appellant's submission, I'll do the same unless the panel has any particular questions for me.
Hearing none, thank you. Case 483, People versus Barber. The appellant has submitted. The respondent is virtual. It's supposed to be virtual. And there she is. Counselor, you may unmute.
Thank you.
Good morning.
I think I'm unmuted.
Yes, you are.
Okay. In light of their submission, I would do the same as the previous respondent, unless there are any questions of me.
Thank you.
Okay, thank you.
Case 484 is People versus Campbell.
Good morning, Fabian Santa Croce for Mr. Campbell. I'd like to discuss point 3 of my brief. The evidence was insufficient to charge the statutory ruin presumption because the small vial of crack cocaine was not in open view. The 2 most recent Court of Appeals cases dealing with the drug factory presumption, Kim's and Hogan, use the term plain view synonymously with open view. And here, the small vial was not in plain view because the incriminating character of it was not immediately apparent. There's testimony from the investigator saying that he was unaware of what was inside of the vial until he was standing on the kitchen sink and looking at the shelf. It was hidden from normal sight on a shelf with a lid that obstructed a portion of it on top of a cabinet. And so in essence, it's on top of the cabinet, but only thing above it is the ceiling. Exhibit 7 is the only picture we have of the vial. It's quite blurry. You can see that there's an obstruction. You can see the liquor bottles behind it. None of the other pictures submitted can you see this vial up on the shelf. In essence, I don't think that this is the presumption was designed to remedy this situation. Drugs on a kitchen counter, drugs on a.
Say, even if it were an open view or plain view or both, you have close proximity issue as well, right? So your client it seems like in Kim's, the Court of Appeals was saying the room presumption, drug factory presumption applies if somebody's in a room and they're packaging, cutting, weighing drugs. The police come in, the police can't determine, they can presume, we can presume that if you're in that room under those circumstances, you possessed it. Here, and then in Kim's, they said, being the defendant had just walked outside, that's not close proximity. Here, your client was upstairs in underpants?
That's
or
correct. I think just underwear. That was the testimony, yes.
Underwear?
Yes.
Yeah, difference between underwear and underpants, just as much.
That's already bad.
So your alternate argument is that's not close proximity.
That's correct. I thought the open view was stronger, but if the court thinks that close proximity is stronger, that's fine as well. And I did put that in my brief. But I think what you were saying kind of is what I was saying, which is it's not a situation that the presumption was designed to remedy, where yes, moments before we're coming in and there's, baggies strewn about and drugs and, all the other cases talk about, drugs on a kitchen counter, drugs on a coffee table, things of that nature. And that's not the situation we have here. And I don't think the error is harmless because we don't know if the verdict was based on, this presumption or on constructive possession, which in essence takes me to my next point, which was.
But before you get there, why didn't you argue that it also, the fact that the presumption was not applicable, why didn't you also equate that with the drug paraphernalia? Why didn't you?
It applies to the drugs, but as the prosecutor put in his brief, which I'll go to, he's talking about Bundy, which is a Court of Appeals case, which in essence says that, if you're the finder of fact infers that the drugs are part of the statutory presumption that the paraphernalia is. So, I suppose if you agree with me, you could send everything back. And I think the circumstantial evidence, you would send everything back based on that. And I can talk about circumstantial evidence if you'd like.
Well, it
but
sounds like without the presumption, then the charge should have been given. If the presumption is proper, you lose on circumstantial.
Exactly. Unless the court has any more questions. Thank you.
Thank you. Mr. Ash, welcome. Thank you.
Mr. Ash for the people, Ryan Ash for the people. If I want to talk about the insufficiency to charge the room presumption argument, I think the standard, I believe, is whether a jury or fact finder, in this case, of a bench trial, could reasonably conclude that the presumption applied, and that's when it's proper to charge. The people don't have to prove beyond, to 100% certainty that the charge is going to be, found guilty on before it's applicable to be charged. And here we have a bench trial where the fact finder is presumed to follow the law. So whether or not the charge is given doesn't automatically result necessarily in bad law being relied on, because the court could say, well, really the defense did defeat that presumption. In this case, there wasn't a lot of evidence introduced to rebut because it was all people's evidence, but at the same time, the fact finder can still reject it. So it's not you lose on this argument, everything is instantly rejected.
So you're saying if the charge was improperly considered, because it wasn't given, it was just Judge Schiano said, I will consider it on the bench trial.
Right.
If it was improperly considered because the defendant, the drugs on the refrigerator, I think, is that where they were on top of the refrigerator?
I think they're on cabinet
Okay.
above the sink. Yeah.
Yeah. If they weren't in plain view, or in the alternative, if the defendant was not in close proximity, the charge shouldn't have been considered. You're saying if the court shouldn't have considered it, we could still affirm because we're not sure. In his mind, he might have said that it was rebutted, that presumption was rebutted. And there seems to be plenty of evidence of constructive possession anyways.
I think, right, the language should not have considered it. I think it's fully okay to consider it, whether or not you're actually going to apply it.
Yeah.
Right. I think regardless of that, there still is circumstantial evidence, or even direct evidence really, of constructive possession. So the
Right.
actual possession here comes from the room presumption. But all the evidence leading to the fact that the defendant lived here, whether or not he's sleeping, I certainly sleep the place I live. So whether or not he's sleeping, he lives here. That's evidence, that is direct evidence that he had constructive possession over everything in the apartment. The mail was
Yeah.
found in the.
That goes to whether the evidence is legally sufficient or the verdict's against the weight of the evidence. But on the charge, would you agree that the defendant was not in the same room as the drugs?
Not in the same room, yes, but that's not, same room is really not part of it.
Right, I'm not saying that doesn't necessarily follow he wasn't in close proximity, but you will give me, he wasn't in the same room. He was upstairs. The drugs were
Yeah,
downstairs.
almost as near as you could get to, spatially, threshold of another room. He wasn't in his bedroom.
But he was up a flight of stairs from the kitchen.
Yes, that led to the kitchen, yes.
How many stairs do you know?
I was one flight, so I was standing
Okay.
flight.
So he wasn't in the same room, but he was close.
Yeah,
What about her argument about they were situated such that it wasn't, you couldn't really see it?
yeah,
It's not like it's
so-
on a table. A lot of our cases, they're right out in the open. Anyone can see
exactly.
it.
The problem with my issue applying that argument here is that the plain view requirement is normally a exception to a search and seizure, like a warrant requirement, right? Here, that's not the case. The drug factory presumption relying on the plain view doctrine is not we're not worried about whether or not the defendant's rights were violated. We're worried about whether or not we can apply this logically to the defendant owning it. Now, we know if this case came out the other way, defendants could easily perch whatever drugs they had just finished packaging slightly out of view, and the presumption would be essentially, they would have defeated the legislature. I think the open room.
Right. Let me ask you this. Does the drug factory presumption apply? Because here there were scales, there were baggies, there were some indications that there was a drug factory there, but it sounds like the presumption was meant to apply when the police come in and they're in the process of packaging and weighing and so forth. What if the situation where it appears possible here, they had been packaged a while ago, the scales were away, the baggies were somewhere else, the drugs were here. They weren't it doesn't sound like he's upstairs in his underwear, underpants, whatever you want to call it, his garments. And they weren't in the process of cutting and mixing and weighing at the time.
Right. I think the issue with trying to draw that sort of temporal limitation to the presumption is that it's quite clear that, our contention is that this was a drug factory. And so we're just trying to apply the presumption to it.
Right. Once a drug factory, always a drug factory, even if it's not in operation at the moment the police arrived.
It's our argument that it was in operation because there were
currently when the police rolled in.
Well, I guess we have different definitions of operation necessarily, but certainly the court could have concluded that it was an operation because there's scales there within arm's reach of one of the people that we're contending was essentially running the operation in shifts.
Okay.
Your panel doesn't have any other questions. I'll submit the rest of my papers. Thank you.
Thank you. 486 People versus Ernest Johnson. Mr. Keem is virtual for the appellant. Mr. Keem, good morning.
Good morning. May it please the court. Brad Keem and I represent Ernest Johnson. Here we assert that the trial court should have allowed Mr. Johnson to withdraw his guilty plea. Initially, contrary to the people's claims, the issue is not foreclosed by the waiver of appeal. On the merits, Mr. Johnson made several claims of innocence at different points in the proceedings. He wrote to the trial court. He, at the plea proceedings themselves, he said, I can't plead guilty for something I didn't do. He made clear.
Yeah, but he was given an opportunity to talk to his attorney, correct? The court kind of put a hold on it. Go talk to your attorney, figure that out. And then I think what happened was the court changed or put different words down and he could then allocute.
Yes, I would agree with that, Your Honor. But then at the very next proceeding, he then requested to withdraw. And then you look at his prior protestations of innocence, his post-plea protestations of innocence. I think that if you look at that as a factor for withdrawal, I think he certainly checks that box. Another box he checks, I think, is mistake. The district attorney's office said that he would have mandatory consecutive time that would lead to a 70-year to life term, when in actuality there was possible that it could be concurrent. So I think that's another checkbox. The third checkbox then would be the ineffective counsel, the counsel at the actual plea proceedings, which, defense counsel said for the very first time, she went over the actual factual allegations. And yes, Your Honor, they did have an opportunity to talk about them. But when there's just nothing on the record really indicates that he was ready to plead guilty at that time, when defense counsel is saying this is the first time that we went over the factual allocutions. And this is a very serious 20 years to life term that we're talking about.
Was he ready at a previous time with his 4 or 5 other attorneys?
Your Honor, he did go through several attorneys, but I think it's unfair to penalize him
They're penalizing him. He had many opportunities to be informed of the factual situations and the sentencing parameters that were available. And I think the court had made that point to the various other attorneys wherein your client was present.
So after defense counsel Carey, defense counsel DiMartino came, and a defendant just continually wanted to withdraw. Defense counsel DiMartino declined to do a withdrawal motion, and I believe the 5th defense counsel came at that point, finally did a motion that didn't include an affidavit by defendant. I believe that this record truly reflects that this is not a plea that we should, push through, and that he is demanding his ability to go to trial. And whether that is certainly he faces a greater term than what he was provided. And I think that the case law and the evidence on this record supports that this court permit the withdrawal of his guilty plea. Unless there are questions on our other issues, then we'll rely on our brief.
Thank you, Mr. Keene.
Good morning, Elizabeth Denman for the people. Your Honors, we would submit that the defendant was afforded a full and fair opportunity to withdraw the guilty plea, not only during the plea allocution itself, but then he was immediately provided with new counsel in order to make a motion to withdraw his plea. He equivocated on that, contrary to the defense here. The defendant equivocated was up till the eve of the second sentencing proceeding on whether or not he wished to proceed with the plea, whether or not he wished to withdraw the plea. He did, in fact, sentencing was adjourned on 2 different occasions, and he did submit a motion to withdraw the plea, in which he articulated essentially the same complaints he has now. And the court determined extensively on the record, according to its own recollections, the file, reviewing the transcript of the plea, looking at the plea allocution, and the fact that this case had been pending for 3 years, and determined that it was not, that it would not, that the motion would be denied. So we would submit that he was afforded a full and fair opportunity to withdraw the guilty plea, Your Honors. So unless there's any further questions.
Thank you very much.
Thank you, Your Honors.
Case 487 is Cowley versus Kaleida Health. Did I pronounce Cowley right, or is it Coley?
I don't know if anyone actually.
Okay, I'll do better.
Is it underwear or underpants?
Yeah.
There.
Good morning, Your Honors. Mark Titici for Kaleida Health, the appellant. Your Honors, as you know from our briefs, there are several issues we have with the decision below. I'd like to group those into sort of 3 buckets for you today. First, some interpretive issues. The decision below held that it was unambiguous on the face of the documents, the Kaleida self-insurance plan, and also the employment agreement, that Dr. Coley was entitled to coverage. In our view, that's exactly backwards. They unambiguously provide the opposite. And if you have to consider any extrinsic evidence, that evidence shows clearly that he was not entitled to coverage. Second, the self-insurance plan is not other insurance or even equivalent to insurance for purposes of Milmick's other insurance clause in the policy that they wrote for Dr. Foley. And third, delay. This case never should have reached the merits determination in the first place. Dr. Foley was aware of the self-insurance plan back in 2008.
Had he been given a copy of the self-insurance plan?
There's nothing in the record suggesting that he was given a copy of it. There's nothing in the record indicating he asked for it, and nothing in the record that says that when he was sued, he went to Kaleida Health and said, I've been sued. This claim has been brought against me. Will you defend me? Again, he was aware of the existence of the plan, but also aware that his employment agreement required him to maintain private insurance, and was told that in the employment agreement that would be his coverage. And that's what he did when he, as the record is clear, when he was sued, that's where he went. He went to Milmick, he reported it to Milmick and then to his excess carrier as well. And then in his discovery responses in 2013, he made clear he had two sources of coverage. The self-insurance plan wasn't one of them, just the Milmick and the HPIC policy.
Right. Look, there's a lot of issues here, and I feel bad for the lawyers who are waiting on the next cases because this may take a while. But could we start with, can I get a clarification on your argument regarding notice? As I read your brief, you're not arguing that Dr. Coley, we'll call him, failed to comply with section 6 under the exclusions of the insurance policy. You're not arguing he failed to comply with his obligations under section 6, right? Your argument instead is that a claim was not reported by him to Kaleida.
It's not
under section 1, the general, right?
And section 7, yes, Your Honor. So section 1 is the general, section 7 also. Section 7, paragraph 2 says that if you become aware of a claim or a potential claim, you're required to immediately report that to the Kaleida CEO or their designee. Again, reinforcing the provision in section 1, the general, and I think 4B as well, saying that a claim has to be reported. And section 7 is very clear. It has to be immediately reported. And then section 1 and section 4.
Are you talking about section 6 or section 7?
7. So 7, paragraph 2, Your Honor.
What page of the policy is that on?
Yeah, that is 1578 in the record. It's page 19 of the policy.
Okay.
So I'm sorry, paragraph 1, though. I'm sorry. It's 7, paragraph 1.
Yeah. But you're not arguing
notice per se. No, it's not about notice per se. It's about
your brief references section 7.
I'd have to check, Your Honor. I believe so, but I'm not sure.
I read your brief carefully in the reply brief. I read it as saying this is a reporting a claim.
Yes,
argument, not a notice of occurrence,
correct.
Not a notice of lawsuit.
Yes, that's right.
Okay.
And and section 7 is about reporting. That's why I mentioned it, is because it uses the same language of reporting the claim.
Come down, the argument, the issue really boils down to who has to report the claim. Does it have to be the insured Coley, or can a third party report the claim? Would you agree that's the issue we have to decide?
Yes.
Yes. And the other side says, well, the claim was reported, the claim being the lawsuit, because Kaleida got a copy of the summons and complaint from the plaintiff in the underlying action. And the policy doesn't say who has to report the claim. You could have written it, or your client could have written it to say the insured, Dr. Coley, has to be the one to report the claim. It doesn't say that, though. So their argument is the claim was reported. This is a claims-made policy. One of the two respondents agrees with that, one doesn't. But claims-made policy, it was reported with a lawsuit during this planned term before the end of the year. So how is that not a reporting of a claim? That's the question.
I think because, Your Honor, there are reciprocal obligations and rights that come with reporting of a claim. So the reason why it has to be the alleged insured, in this case, Dr. Coley, who reports the claim, is because that is how Kaleida knows that they are being asked to cover. And so section 7.1 we were talking about, and 7.2 sort of go together in this regard, Your Honor, in response to your question. 7.1 says you must immediately report. 7.2 says when you report, we then have the ability to take over defense of the claim against you.
Right. Well, the risk management group did immediately meet, and they assessed the situation, and they concluded, apparently they had always concluded, that a doctor who is on call and performs services on Kaleida is not covered. Now, that's a question of whether they were correct in that,
Yeah.
but they had notice of the lawsuit and they did it. There's a regulation that was cited. It's 11 NYCRR, I think it was 73.3B, something like that. That was cited in one of the briefs. That it's a regulation in New York for insurance that says on a claims made policy, reporting of a claim can be made by the insured or a third party.
Mm-hmm.
Do you agree that that regulation applies here?
Candidly, Your Honor, I had have to look at it again. I don't see, but taking it for purposes of argument, I think even if it does, the fact that I guess
I'll read it to you. I'll read it to you. Okay, it says section 73.3A. I'm sorry, it wasn't B. 73.3A. A claim will be deemed first made when the insured receives written notice of claim or suit from the insured or third party, comma, but this shall not preclude an insured from utilizing written notice of an incident as the trigger of the coverage. So they're saying under this regulation, it could be third party. They had third party notice here.
Mm-hmm.
Your policy, Kaleida policy, says at the end that this is intended to comply with all the rules and regulations and laws of New York State. This is one of them. So even if your policy said no third party notice, I think you would have a problem under the regulation there, which seems to allow it.
I guess it's the difference between notice and then what I think another term of art in the industry would be for tender, Your Honor. I think we had notice. No, I don't dispute that there's notice.
Notice of the claim.
I'm sorry.
Notice of the claim?
Notice of the suit, not notice of a claim for coverage.
Right, but a claim is defined.
I guess I mean, this goes maybe to the inartfulness of the wording, Your Honor, is that claim is, I think, used in a couple different senses here, and the difference between a claim for coverage and the claim against Dr. Coley.
Yeah, I believe a claim is defined as.
I'm sorry, you're talking the regulation or the policy?
Yeah. Policy, yeah. A claim is defined as a lawsuit against the insured.
Mm-hmm.
So,
Right.
It's not, a claim isn't a claim by the insured is I want coverage here. It's
Right.
a claim somebody's suing me.
Right, and the reporting is what triggers the
Right.
claim for coverage. But yes, Your Honor, I mean, I think even if, for purposes of argument, we say that the claim was reported by a third party, again, it's the difference between notice and reporting. I don't believe that the claim was reported by Dr. Coley because there's a critical difference between us having notice and then us having we didn't then have the right to intervene in his defense and say, well, we're taking over your defense now, even if we could have done it, the claim was reported.
Correct me if I'm wrong. Well, first of all, Kaleida was a defendant, so they had counsel.
Yes.
Ms. Sweet, I think it was. There was a determination made by Kaleida's risk management committee that they don't have to provide coverage because he's not a covered person for various reasons.
And
So
I'm sorry.
I mean, so I guess regardless of who reported it, Kaleida would have done the same exact thing. They would have looked at it and said, no, you're not covered because you billed this patient directly.
Actually, that's where I disagree, Your Honor, is that if we'd gotten a demand for coverage, we could have said, we disagree that you're actually covered, but for present purpose, to protect our own interests, we'll defend you. And we'll send a reservation of rights letter to MILMIC and HPIC and say, we want to be in control of this litigation. We want to cover our own selves in this process. And then we'll sort out later who's responsible. We wouldn't have lost the rights that we actually lost through the lack of an assertion here of being involved in his defense. And that's something we didn't get and we could have and would have done if we'd been had the claim reported to us.
I want to address the covered person issue. We were talking about the claim there.
Sure.
The threshold issue is covered person.
Yeah.
Would you agree we look at the four corners of the insurance document to see if somebody's covered person? If it's ambiguous, we can look at extrinsic evidence. If it's unambiguous, then we don't. If it's unambiguous here, we don't get to the employment contract. That would be totally irrelevant. That kind of goes to like what we thought we were going to give him and what he thought he was getting, but this is contract law. If it's unambiguous, if he's clearly a covered person under the policy, we wouldn't even look at that in that insurance contract, right?
I disagree with that, Your Honor, in part because even if the policy the plan would by default cover him. He could sign a contract that said, imagine one that was more directly worded saying, I waive my right to coverage under the self-insurance plan. So the fact that the fact that he would be by default covered under the plan, I don't think entirely ends the inquiry for you, no.
And it seems, I don't know, just me speaking, and I just looked at it, I haven't really studied it, but it seems kind of clear that he was a covered person. He was a physician who was not treating a private patient of his. I know there's an argument, well, he billed directly, but this was a patient who was at the hospital, the Graphics Kaleida Hospital, for a week. He didn't come in, the patient didn't come in to Dr. Coley's office. He's in the hospital for a week. Coley's on call. He gets a call. This guy needs a gallbladder surgery. Can you do it? He has to do. He's got to respond in 30 minutes. He does the surgery. Is that patient a private patient of Dr. Coley simply because Coley has the right to bill for a portion of the services? There's a technical component, professional.
Yes.
Kaleida billed him too, right?
Yeah.
So is that a private patient or is that a Kaleida patient? It would seem on the surface to me tough to say that it's a private patient. But so if that's the case, then we don't get to the insurance contract. But if we do, then we get to this issue of the exclusion in the employment contract with a 6B.
Yes.
That talks about you're not entitled to coverage if you bill directly for your services, right? Isn't it says something like that?
Something, yeah, to that effect. Yes, Your Honor.
And your argument is he billed directly for the services, therefore he's not a covered person, right?
Well, I don't think that covered person is a term of art it means he's not entitled to coverage.
Right, he's not entitled to coverage under the insurance contract.
Yes.
But under what circumstances, he's clearly he's got to be a covered person in some circumstances, right? So if he's billing directly for his services, under what situation would he ever be covered? It seems like he's billing, if it's his own patient that comes into the hospital, he has privileges, he's billing himself, the patient. If he's on call and there's a patient in the hospital he serves, he's billing directly. So when would there ever be, wouldn't that vitiate the whole coverage? There would never be coverage if we read it the way you want us to read it.
I don't think so, Your Honor. I think there are a couple of circumstances where he would be entitled to coverage. I mean, I think one is, so say someone comes into the ER complaining of abdominal pain, Dr. Coley's on call and is called in and just says, oh, it's a kidney stone, it'll pass, and goes back to his office or goes back home. And an hour later, the guy's appendix bursts. And he doesn't perform any services. He's not billing for anything. He just comes and takes a look at the guy, feels his abdomen, says, no, it's a kidney stone. And there's no billing, there's no private billing for it. It's just for that diagnosis that was allegedly
bill for his consultation. I looked at him, I spent 20 minutes with this guy and couldn't he bill for that?
Again, I suppose, I don't know if he could or not, Your Honor. I don't think he can. I think that's the point, is the per diem is intended to cover those encounters, I guess you would say. And then it's the services, it's a professional component as is defined in the employment agreement that covers it. Another situation is, say there's a terrible bus accident, lots of casualties, people coming into the ER. Dr. Coley's all hands on deck. He just comes in, he renders service. He's not billing anyone for that. It's just a sort of almost a good Samaritan situation. He's covered. He's not, it's just no one knows who's treating whom. It's just a triage and someone is financially responsible for what happens. And that's
I don't see the difference though, in the bus accident and what happened here. I mean, he came in, he had stomach issues and Dr. Coley treated him.
Well, he billed him privately for that, Your Honor. We're talking about,
if Dr. Coley bills the bus accident people privately, you're saying he's outside that.
I'm saying, well, I guess I was positing a situation where there's no billing that's happening. No one's able to keep track of time and services. It's a true triage situation where it's all hands on deck and he's just, for those purposes, part of the core of people who are helping, emergency response victims in need. And so in that situation, again, would not be billing privately for it. And therefore it's all the president's man, Your Eyes. It's follow the money. If he's billing privately, he is covered by his own insurance. If he's not billing privately, he's covered under the.
So he either works for free.
Well, not for free. It's a daily stipend.
$300. Yeah. So, all right. One of the other difficult issues of many in this case is the other insurance.
Yeah.
Kaleida had other insurance clause.
Yes.
Milmick had one. It's not, would you agree that HPIC is a true excess coverage?
Yes,
Okay, because they named Milmick.
yes.
So on this issue, it sounds like you're arguing Kaleida is not other insurance with respect to Milmick's policy because Kaleida was self-insured. And so there, and you cite some cases there.
Yes.
Could you explain, it's a little confusing on
Yes.
like this Hertz case that was cited and some others. The difference between somebody who just has no insurance at all
Mm-hmm.
and says, I'm going to write it out. I'm going to pay. If somebody sues me, I'm paying out of my pocket. Now for automobile in the Hertz case, they had to get a certificate from the DMV
Yes.
that show I have the money to pay. It sounds like there, that was true. No insurance. We will pay whatever. Is this different? Kaleida, they name insurers. They have a written policy and they name people or they name classes of people who are going to be covered insurers. They have policy limits. They have notice requirements. Is this, it's called self-insurance, but is it the same as if somebody just says, forget it, I'm going to have no insurance. I don't want to pay the premiums. It's cheaper if I got to pay if I get sued. Is there a distinction between those two situations?
I'm just going to roll the dice in a self-insurance plan, essentially.
I'm sorry?
I'm just going to roll the dice in a self.
Actually, no plan at all.
Right.
And because there's no limits in that too.
Mhm.
If you're self-insured, truly, there's no limits. You had limits in the Kaleida. Was it 3 million or whatever it was?
Yeah, and I believe they themselves, I think, had an excess or catastrophic level of coverage themselves. They purchased for above that.
So is that different? These cases, you cite a lot of cases.
Yeah.
There's a second department case you rely a lot on. It seems on point. I don't know. I haven't looked at the record on appeal or anything, but they say your self-insurance, it's kind of a misnomer. It's not the same as Hertz.
I think it is. I understand that there are differences in terms of like they're covering cars and driver's liability, and we're covering doctors. So I think that there are parallels there, Your Honor. But I do think there is a fundamental difference between insurance and self-insurance, and I think a difference between the person who's just sort of riding it out. We're not just sort of an uninsured motorist or someone said, I'm just going to sort of take my chances, because it is a going concern. It's a health system that needs to be able to operate and needs to be able to hire physicians. I mean, again, the point here was to have a distinction between staff physicians who part of their deal for coming to work for the hospital is they are covered under our insurance. They need malpractice insurance, right? And so they are covered. The idea is they will be covered under the self-insurance plan. They'll be indemnified. If the hospital can't credibly say to a physician who's looking at potentially working at Kaleida, we can assure the public, we can assure you that we have the wherewithal to withstand judgments. They can't operate as a going concern. They can't be a business. That's in some ways the fundamental difference between that and the person just saying, I'm going to roll the dice and hope I don't get into an accident. I hope I don't hit anybody. I hope I don't get sued. The difference is I guess the flip side of that between insurance and self-insurance. Insurance is the externalization of risk. It's outside hedging of risk. Self-insurance is the exact opposite. We're saying just we will maintain the financial wherewithal as an institution to withstand these claims against us. And the other point I'd like to make on that, Your Honor, in terms of the other insurance clause is that, as Your Honors know, Kaleida's other insurance clause specifically references self-insurance. And one of the, I think, points of dispute between us and Milmick on this is that Milmick is obviously a sophisticated insurance company. It knows that self-insurance plans exist. If they wanted to include self-insurance within what counts as other insurance, they obviously could have done that. They're relying now on the equivalent coverage language. That seems like it's a bridge too far for, again, I think this is a circumstance where the case is saying you construe ambiguities against the insurance company that drafted them. That has some purchase here because
they're using that argument against you a lot.
They're using that against us a lot. I don't think that's entirely fair because the insurance companies are in the business of writing contracts. That's what they do. They have actuaries that assess risk, and then they write a contract that balances the risk and the premiums, and they write a contract that is their business model. That's what they do for a living. That's not what we do for a living. So I don't think that it's entirely fair to export those just because this is a self-insurance plan those case law to this context where we are the drafters of an employment agreement.
If we agree with you that Kaleidah's self-insurance plan is not other insurance within the meaning of Milmac, then what ensues? Milmac has to exhaust the $1.3 million?
Yes.
Can we say publicly what the settlement was, or is that confidential? The settlement of the underlying personal injury action?
Yeah,
Is that?
It was subject to confidentiality.
Okay.
Yeah, it was, yeah. This, you know, that wasn't part of the negotiations.
So
yet,
I won't mention that, but if the Kaleida policy is not other insurance, your argument is the first 1.3, it's got to come from Milmac.
Yes.
And then what? What's the balance, if there is any? Does it go to Kaleida or does it go to the excess carrier?
Again, our argument is that it goes to the excess carrier. I think that there's a closer. Well, I think the argument is that I think the Lumberman's and the sort of dividing the liability between the carriers at the same level, I think has more weight there, Your Honor. So I think they try to make, I think the answer is, the simplest answer I can give you, Your Honor, is that they, of course, HPIC references only the Milmac policy is what they're access to. They don't reference our policy, they don't reference the self-insurance plan. And we do everything you can do from our ex-ante position. Again, we're not in the position of saying what every physician does with their coverage. HPIC is in that superior position. They have the ability to sort of look at the field when they're writing their policy and say, who are we superior to? We've done everything someone can do from the outset to try to disclaim every other coverage. And you sort of tie our hands to do that if you put us in that position where we're not able to, because another policy also has an excess insurance.
We've covered a lot of issues. There are some left, but your time is running short. Do you want to rely on your brief for those, or is there something really important you want to hit before you sit down?
There's just, I mean, just, I guess on the text, I wanted to rewind to the other insurance, to the covered person just for a second, Your Honor, because I think the critical point on the covered person is the person has to be acting on behalf of or at the direction of Kaleida. And there's no evidence in the record that when Dr. Coley was treating Mr. Jusma, he was acting on behalf of or at the direction of Kaleida. He said he wasn't a Kaleida employee at the time. He testified to that himself, and he billed for it privately. I understand that.
So he has to, before he does any services for a patient at the hospital, not his own, he's got to get on the horn with somebody and say, can I do this? Can I put it? Can I evaluate this person? Can I do the surgery? You got to get approval for he had to get approval for every medical procedure?
No, Your Honor, and the contract does not say that. Section 6B does not say he needs individualized approval for every procedure he does. It just means he says he needs approval to bill. Section 4A of the contract gives him that authority. And he clearly had it because he was billing privately.
So Kaleida like a blanket at the beginning. Can I do it? Yeah, just go forward. Go ahead.
Yeah, and that's exactly, that's the dichotomy between staff physicians who work for Kaleida and on-call physicians who come in, they consult, they do their surgeries, they bill for the professional component themselves. Kaleida bills for the technical component, and Kaleida obviously knows that's what's going on. They've written that distinction into this agreement, and so
wouldn't get anyone to probably be on call otherwise. But would you agree that that provision could have been written a little bit better?
Absolutely, 100%.
It was written. Is that the one written by a paralegal?
Yes, Your Honor. It's a form contract. It is not elegantly written. The only other thing I'll say, Your Honor, is that the test is it clear what the parties intended, and awkwardness notwithstanding, and the hopscotch nature of how many different provisions you need to read to get there, it's very clear that the parties did not intend Dr. Coley to be able to be covered under the plan because he could bill privately. And I'll submit on everything else. Thank you.
Thank you. Mr. Needle is next on the list. He's virtual. Unless you want to go out of order.
No, I'm fine.
Okay.
Is
it Mr. Needle or Needle?
It's Neidl, Your Honor. Can everyone hear me okay?
Yes.
Okay. Thank you, Judge. So unless you want to do it differently, I've made notes in terms of the order in which you approach the issues. So I'll try to move briskly through them in that same order. Okay.
Sure.
First, we discuss the claims made issue, or when was a claim made? What is a claim? That whole bundle of issues. This Kaleida plan is not exactly a claims made policy. It's more of a custom contract, a claims-made policy per New York regulation 11 NYCRR 73.0 is a policy that requires that the loss occur and the claim be reported basically in the same year or policy period. This contract has two different boundaries for coverage. First, there's it has to have occurred within a certain window, specifically on or after April 1, 1998. And secondly, it has to be reported during the so-called planned term, which is, if one reads this closely, it's while the plan is in effect. So how do I get to that? If we look at the professional hospital liability coverage, it's section 4 of the plan. It covers medical incidents which occur on or after April 1, 1998. The
But doesn't section 3 talk about the plan term? Section 3 says the plan term will commence at midnight on April 1st, 1998, continue through the end of the year. Thereafter, the plan term shall commence January 1st, go through each year and so forth. It sounds like you're relying on those last 3 words. It says until the plan is eventually terminated.
Not only those last 3 words, but also closer to the center of section 3, which you're on to now. Thereafter, the plan term shall mean each subsequent calendar year. The plan term, singular, shall mean each subsequent calendar year. That means right now we're in the plan term. It also means last year we were in the plan term.
Right. So Dr. Coley could have,
that says,
Dr. Coley under this could have given timely reporting of the claim. He could have done it 10 years later if he wanted to, as long as the plan was still in effect.
He could have. And the evidence for that is the occurrence bumper at the front end of it. It has to have happened on or after April 1, 1998. Okay, there'd be no reason to mention an occurrence trigger if this was a pure claims made policy. It's you got to make a claim within the calendar year in which it happened. Doesn't say that. Okay, so this loss, the medical incident with Juzma, happened in 2011. That was during the planned term. It happened after the occurrence threshold of April 1, 1998, and therefore it's covered. Now, as to the meaning of claim, let me turn to that for a minute, because as Your Honor, I think was getting to in your questions of counsel, this is basically it's what they're calling a late tender of defense claim. It's not a late notice claim. Section 7 of the plan is not cited in their brief. If you were to run a text search on their brief, you'll find the Roman numeral 7 twice, and neither are in reference to this section. They're actually talking about the other insurance clause in those 2 citations, which is section 8. They also didn't talk about section 7 in their briefs below. And if you look at their complaint, their amended pleading, this is their final word pleading in the case, record 85, paragraph 27, their 5th affirmative defense to coverage isn't lack of notice. It's Dr. Colley never tendered the defense of the underlying action to Kaleida. They repeat that allegation at record 87, paragraph 45. This is in their counterclaim pleading for why he should be denied coverage. Dr. Colley never tendered the defense of the Juzma action to Kaleida.
But he did tender it, didn't he?
Not giving notice. Yes, Your Honor.
He did tender it, didn't he? Didn't he tender the defense on multiple occasions? I think that was on page 48 of the record.
Well, certainly, I don't have 48 in front of me, but certainly he tendered it by the time that he sued his declaratory judgment in this case.
Like 8 years later.
He didn't need to tender it, is my point. There's no requirement in this document that says they're conflating claim with tender of coverage. This document conspicuously defines a claim as an allegation of wrongdoing or request for money damages against the physician. Okay, that's section 5 of the plan. That is someone pointing the finger at the doctor and saying, you're a tortfeasor or you owe us money or both. Okay, that's the claim. It's not, excuse me, Kaleida, will you cover me? That's not a claim. And there's no requirement in this document that Dr. Colley raise his hand and do that. He wouldn't even be able to, because as one of your honors referenced in your questions, they don't share a copy of the thing with the physicians.
Yeah, but Mr. Neidl, the employment contract makes it crystal clear he's entitled, that he's covered under the Kaleida self-insurance plan. He can't say he didn't know he was covered. Maybe he didn't have a copy of the policy, but it doesn't sound like he ever even asked for one. It's kind of partly on him, Kaleida, maybe on them too, but he didn't even consider it. I mean, this is a very unusual case in that the insured had no idea he was even covered, and he had other coverage. I can't recall seeing a case of happening like this, and probably may not again, but in any event, he knew or should have known he was covered under the Kaleida plan because an insurance, his employment contract that he signed told him he was.
But the section 6A of the contract doesn't tell him what to do. It doesn't tell him how to report a claim.
I agree.
Or that he has any obligation to report a claim. And Allison Spaulding, the general counsel, testified that's not usually what happens because these folks don't get copies of it. What usually happens, and what she testified she believes happened here at record 1537 to 38, is that the determination was made when the summons and complaint claim came in, which was October 2012. And that summons and complaint was a claim. It certainly was an allegation of wrongdoing and a request for money damages. And according to Ms. Spaulding's testimony, they look at it, they decide, are we covering anyone? If they are, they tell those folks that are covered the good news. They don't tell those who aren't covered the bad news. Okay, it came up later in discovery that this thing existed, and that's how we find the litigation in front of us now. But they're conflating. The claim was received in 2012. It was certainly received no later than when this action was commenced, which was during the planned term. I'll move on to the next issue unless you have any more questions about that. Covered person. The argument that they recite in their brief for Dr. Colley not being a covered person is the language in the plan section that defines a covered person as a physician who's acting on behalf of or at the direction of the named organization. Okay, he was performing his employment agreement, and the scope of his employment is defined right on the first page of the agreement. It's to provide surgical and clinical services to Kaleida Health and its patients. That's the very first whereas recital. Kaleida Health requires the services of a physician to provide on-call clinical services to Kaleida Health and its patients. And it goes on in subsequent paragraphs to discuss surgery. That's why he was there, working on call in the ER department. Attached to that same employment agreement, there's 20 some odd pages of Kaleida policies and procedures that he has to follow.
Would you agree that under the policy he's covered? Your argument is he's covered because he's a physician, not because he's an employee?
He's covered because he's a physician acting on behalf of the named organization.
So not employee, because in parentheses it says an employee, not a physician. There's been arguments that made that he was an employee by a number of people in this lawsuit. That doesn't seem to apply here.
I think the other subpart you're reading, employee, not a physician, there's several categories of covered persons. That one pertains to non-physician covered persons.
Okay.
His is subsection B, which pertains to physician, any physician employed by the named organization. And he is employed. He's got an employment agreement. Acting on or behalf of the direction of the named organization. So in other words, when he's not in private practice, right?
That's why the issue comes down is the treatment of the plaintiff in the underlying action. Was that done pursuant to his private practice, or was that pursuant to his employment for Kaleida?
There's no evidence that it was private practice. Mr. Jusma testified, his testimony's in the record. He had never seen Dr. Colley before that consult in the ER. The surgery happened the next day after his consult. So there's no evidence that this was a patient brought in from some prior appointment in Dr. Colley's office. Both parties, by both parties, I mean Dr. Colley and Kaleida, behaved consistently with this being an on-call transaction under the employment agreement. In what way? They both billed. Colley billed for the professional component of his service, which he was entitled to do. It's part of his compensation as an employee under Section 4A, and Kaleida billed for the technical component. So they both treated it as they would any other employment within the scope of employment episode. There's no evidence that it wasn't that. If I could briefly comment on the employment agreement, obviously it falls to the court to try to interpret this agreement in a way that doesn't render any subpart of it completely without meaning. And Justice Lindley, your questions about under what circumstances would there ever be coverage here, if I think are apt. I mean, Section 4A of the agreement says he's entitled to bill and collect fees for work he does on call pursuant to this agreement for the professional component of his services. Ms. Vorpahl, the VP of Physician Services, whose paralegal drafted this agreement, at page 306 of the record, when asked, is there any episode of service he could deliver that wouldn't generate some billable professional component, she couldn't think of one. Okay, so I reject counsel's example of 1 in a million example, perhaps, where Dr. Colley walks up, has a brief conversation with the patient, doesn't do anything and doesn't bill him. This everything he does when he's interacting with the patient, even giving a consult, could be billable. And the problem with Section 6B of the agreement is it would nullify any coverage under the Collided plan and therefore negate 6A because it purports to kick in any situation in which Dr. Colley not merely bills for services, but has the right to do so. Okay. And so
Right. In your view, it would render meaningless,
all the time.
right? It would render meaningless the covered provision, but
Right.
you're talking about the employment contract.
Right.
Would you agree with me that we don't get to that if the insurance plan is unambiguous? You just talked about covered person under C, a physician employed by the name organization for the purpose of providing patient care while acting on behalf of the direction of Collida. If that's unambiguous, like you say, it's end of the analysis, right?
I would see it that way. I don't know if co-counsel said, but my meaning to that being that Dr. Colley would be covered, regardless of what this other thing says in his employment agreement. That's my view of it. As for the other insurance issue, so what's quite clear to me under the New York case law is whether something is other insurance or not under one of these other insurance clauses is a question of contract interpretation. Okay, if we look at the actual cases cited by both sides, that is the way the courts try to solve the problem. Right? We cited a case, liquidation of Midland, in which the court said, well, it merely says other insurance, and we don't think that's enough to put the insured on notice that would mean a self-insured retention or some other self-insured resource. But in this case, Milnick's clause doesn't just say other insurance. It says any other valid and collectible insurance policy or equivalent coverage. That means something other than a collectible insurance policy. Otherwise, we'd be rendering it redundant. It must mean something else. So it's something similar to an insurance policy, but something different. And it's not surprising that we would see language pop up in policies nowadays that we didn't see in liquidation of Midland to cover that, because self-insurance is more common now. There are in-house self-insurance programs more common now than they were once upon a time. So
could you address some of the cases cited by the appellant on page 23, 24 of the brief, one of which is the American Casualty of Reading, Pennsylvania case, Second Department case from 2005. There's language in there that seems very supportive of Collida's position. How is that factually distinguishable?
So
yes,
I think legally it's pointing to the same analysis that I've just endorsed and that I think is endorsed by the other cases, that it's a question of contract interpretation. The American Casualty case says, we don't think that self-insurance plan is other insurance, quote, as defined in the plaintiff's policy, close quote. The practical difficulty is American Casualty doesn't tell us what the language of the policy was. Okay, so we don't have that direct factual comparator, but it still approaches it as a contract interpretation issue, not some broad New York policy issue. If you read Collida's brief, it would suggest to you that as a matter of New York policy, uttered by the Court of Appeals in Guerrico versus Hertz on down, we've taken some moral stance that self-insurance is not other insurance. That's not true. Okay, in Guerrico and in Consolidated Edison, they're talking about voids of insurance. Hertz didn't have insurance, so it couldn't be liable under a statute that applied to the insurer of an automobile tortfeasor. There was no insurance.
so that statement from the Court of Appeals in Hertz, it was something like self-insurance is no insurance.
Correct.
That is inaccurate. Well,
I think
that led to a lot of confusion here.
In the context of the Hertz case, that's a rational thing to say. You're saying, well, Hertz doesn't have any insurance. There's no coverage. So how can you treat it like it has an insurer? Okay. But in this case, we're not talking about avoiding coverage. The other insurance clause that we're trying to interpret is the Milnick one, because that's the one that Colley as policyholder is reading. That's the one that the policy is talking to. And it's telling him, if you've got a collectible insurance policy or other equivalent coverage, you have to go there first. So what does that mean? Okay, well, from Colley's shoes, that's not a void in insurance. He's got two recovery resources, the Milmick policy and the Kaleida plan. Neither one are a void of an insurance or no insurance at all for him, the way it was for Hertz and Guerico. Okay, these are competing resources for insurance, and the Kaleida plan certainly is equivalent coverage. It contains coverage agreements, that's what they call them, for hospital professional liability services and comprehensive general liability, a term of art used in insurance all the time. It sets coverage limits, it has exclusions, it even has its own other insurance clause. So it is if anything is equivalent coverage, it is this sophisticated thing, this Kaleida plan. And both were available to Colley. It's up to you to decide whether he was covered by them or not. But if he was, it is other insurance or equivalent coverage. It's not
any other issues?
Retention, which is what these other cases are talking about.
Do you want to move on to latches or any of the other remaining issues before your time is up as it's running?
I had jotted down one other issue to address. I can't seem to find it. I mean, latches, I would just say briefly, there is no prejudice here because they received the summons and complaint in October 2012. They answered it by November 2012. The claims pled against Kaleida were vicarious liability. You're liable because your doctor, Colley, was negligent. Okay, they were in on the ground floor defending that case, developing the record factually, okay, through depositions, discovery, etc. They deposed Dr. Colley. Dr. Colley was deposed. He testified before he passed away. And they have not cited any prejudice that has occurred. There's no description in the record from any witness. We would have done this differently with the case if we had known we were going to be liable, not merely on vicarious liability, but for some other reason, or that might have been explored if he had lived longer. I mean, the only prejudice they cite in their brief that I could discern for latches is they didn't have the chance to ask Dr. Colley what his subjective view was as to whether he was covered by the Kaleida plan. My answer to that would be it doesn't matter what his subjective view was. That's not how these things work. We don't ask insureds to prove that they believe they're covered or that they're free from doubt that they're covered. The document speaks for itself. So I don't.
He really didn't. It wasn't a top priority for him because he had coverage from Milmick and he had excess coverage as well. It's not. If he had no coverage at all, he might have been a little more interested in that self-insurance plan. But we understand your argument and we appreciate your time.
So I'll yield and thank your honors for hearing me.
Thank you.
Oh, sorry. As a housekeeping thing, I hate to interrupt with this, but just so you know, I have on my screen today's calendar, and somehow in case 491, I have become listed as arguing that case, and the two actual parties are on submit. I'm just seeing this now. I will have my assistant call to see if she can have that taken down, but when you call case 491, that is not my case and I will not be here.
Okay, yeah, I was wondering that. We have another lawyer who I think is scheduled to be virtual there, so we appreciate you letting us know.
Okay, thank you. Bye.
Thank you, Mr. Pieper.
Morning, judges. Steve Piper, Hurwitz Fine on behalf of Milmick. There's been extensive argument, and Mr. Noddle raised some very interesting points. But I'm a pretty simple guy, and I would tell you that if you just read the contract, it'll tell you the right answer, right? I said the same thing to the judge in the underlying action. If you just read the contract, it will tell you the answer.
Which contract are you talking about?
The only contract that matters, the insurance policy, which is wholly self-inclusive, or the self-insurance plan. The preamble of coverage, right? That which is covered, the plan, we have that. On behalf of covered persons, we've talked at length, Judge, and I'd be delighted to rehash those arguments. But Dr. Colley's a covered person here. He's a physician acting on behalf of under an employment agreement that he testified, well, yeah, I got called to come in as a result of my on-call responsibilities under the 2008 employment agreement. So he's clearly performing physician services. Kaleida never challenge that until today. They recognize it. Go back, you can read Ms. Vorpal, her testimony. She acknowledges that he's performing services on behalf of Kaleida as a result of the employment agreement. So he's a covered person. So we got that. all someone's gonna be legally obligated to pay because of bodily injury. Surely we have bodily injury, right?
Medical incident.
Covered under the plan caused by medical incident. There's no doubt we have a medical incident here, right? So we get to this final part. For a claim first made against the insured and reported to the Kaleida Health. Judge, you're absolutely correct. What this doesn't have in it is an obligation for the insured or the covered person to provide notice into this preamble.
This could have easily put that, some policies we see do have it, right?
100% they could have, Judge. And we cite the Gilbane case, which is directly on point on this concept. You wrote the plan. If you wanted to create specific duties and obligations, you had to do it, right? There was an additional insured case that turned on whether or not such person was in it. But if they would have included the same language, we'd have a different argument.
Am I right on that regulation 11 NYCRR 73.3 that says on a claims made policy, the claim can be reported by the insured or third person?
I would agree with that, Judge, and I think this is a claims made policy.
So if you want to rewind a little bit, they couldn't have said, because they have to comply with the regulations. So Kaleida couldn't have said it has to be made only by the insured.
Exactly right, Judge. Not only couldn't they have done it, because it would have been a violation of the regulations, they didn't. They could have, if they wanted to, if they wanted to test it, they included such person, they didn't.
Right.
So what do we end up with?
Just to narrow those issues, I apologize for
Sure,
interrupting you here, but we do have some other cases here. This is not a notice case. This is a reporting of a claim. So you represent Dr. Coley as a state, so forth. You're not saying, well, we have a reasonable excuse for failing to give notice, because there's those cases that say we have an excuse and it's whether it's reasonable or not. That's not an issue here because it's not a notice case. This is a reporting a claim case. They never cited this section 7 of the policy in their brief. I think counsel, during argument, he was probably on his computer searching it, and he confirmed what I had said. It's not part of the case. So we don't. You do make a reference that, well, he didn't know he was covered. He didn't even have a copy of the plan, but you're not raising that as an excuse for failing to report it.
Fair question, Judge. Let me tie it up this way. Kaleida, respectfully, is looking for a way to try to explain their way into an argument here instead of looking to create coverage. That's what they're doing. So what they do is create this amalgamation of, well, we'll go to the notice provisions and we'll bootstrap notice provisions onto the preamble of coverage. And under that, then we'll create some sort of notice of claim requirement. That ain't how it works. They have the provision that we just went through and it applies on its face. Section 7, what they're talking about is exactly what you're talking about. Those are conditions preceding to coverage, which any insured has an obligation to comply with. Problem with Kaleida that they didn't mention in their argument, and they've tried to skirt in their briefs, they never raised it.
Well,
and a condition preceding is raised if it's not raised.
Well, they would have to disclaim on that ground too, right?
100%, Judge. That's correct.
You don't have to disclaim, which is probably why they're going on the reported claim. If there's no coverage, you don't have to disclaim it. So we're in the reported claim box. For a lot of reasons. If we're in the other box, they lose because they never disclaimed that.
That's exactly right. They waived any late notice argument because they didn't raise it under Schiff versus Flack, which is a Court of Appeals case from 1980 and hasn't been changed in 45 years. So they're trying to use that to support this argument on the grant of coverage. And Your Honor is 100% accurate with what's going on here. The language in the preamble of coverage 100% applies to provide coverage to Collie, full stop. And any argument about notice in Section 7 is waived and long gone because they never raised it and they can't raise it now. So with that being said, Judge, we're in coverage, right? So this whole concept of the employment agreement, by the way, that was the entire argument up until the briefs. You can see it through the deposition transcripts, was this employment agreement somehow applies. You know, it's never referenced in this self-insurance plan that they drafted and have used nonstop since 1998, any reference to the employment agreement. So they want to take an employment agreement that they drafted 9 years later, and they want to bootstrap that onto the coverage that they wrote.
It was not incorporated.
Not incorporated at all.
Right, but there's been a lot of inconsistent positions been taken, one of which wasn't by you, I don't think, but by your client's lawyer, who said there's no coverage. If there was a coverage, I would have asserted it. Your client took the position that he was not a covered employee in the underlying action very clearly in an attempt to, but in any event.
Let me put that into context for you, Judge. Mr. Danny is an excellent, very, very well-respected, an excellent trial lawyer, med malpractice lawyer. He ain't a coverage lawyer. Because if he was, a coverage lawyer would say, I can't make a determination of whether or not my client is entitled to coverage until I see the contract. And in the context of that decision, he didn't have the contract. Why didn't he have it? Because Kaleida wouldn't turn it over. The whole concept of Dr. Colley, you should have known all these concepts and things in the policy. They didn't turn it over until we sued them.
Did they disclose the plan, but they didn't hand it over?
They did not disclose the plan. In their discovery responses, they disclosed the coverage available under the plan, but they never disclosed the terms and conditions of the plan. They said, oh, we got coverage and it's 5 million or whatever it is.
Coverage for Kaleida, but not for Dr. Colley.
They disclosed Kaleida's omnibus discovery responses in the underlying action, I think 2012 or 13. Disclosed that we have coverage. Again, we have coverage. And this is the limit of our coverage. Not we're self-insured, we can pay anything. We have a policy which provides this. If you go back and look at the back and forth in that January 4th, 2019 appearance, the whole point of this comes up with Kaleida indicating, well, he might be covered and then he's not covered. So we asked for the policy. We didn't get it until we sued them. And it's under strict confidentiality. So they didn't turn it over. Walker versus Erie, Judge Ogden, you mentioned it right off the bat here. Walker versus Erie is exactly on point with what's going on here. How can my client possibly comply with the terms and conditions of a contract when they don't have it? And in fact, they had to go through formal litigation to get it and then make it subject to significant confidentiality provisions. This case is under seal as a result of the self-insurance plan. So with that being said, he is a covered person. This policy covers him. Clearly, this is entitled to cover him. And this employment agreement, I think, doesn't make any impact whatsoever. But even if it did, it still doesn't change the terms and conditions of the policy of the self-insurance plan. So the last point here is this concept of other insurance, unless Your Honor has any other questions.
That's the one that I am struggling with the most.
Kaleida, again, looking for ways to avoid the contractual obligation they have, gets finally to this concept of other insurance. But they won't even admit that it's other insurance, despite the fact that they call it other insurance throughout the terms of the contract. And they have another insurance clause. It's awfully difficult to comprehend if you're not insurance and you don't contemplate sharing with another insurance policy, why you would have another insurance clause. But they do. Before we get there, though, definition of physician in the policy. That's what makes him a covered person, correct? Definition of physician includes purposes of providing services and subject to other insurance. The coverage that's provided under the plan for Dr. Colley is written to be subject to another insurance analysis. So this concept of, no, you don't have to get to that court because we're not other insurance and therefore we're not subject to the very terms and conditions of the policy that we wrote. It's a red herring. This case is Lemuro versus State Farm and its progeny moving right down from the Court of Appeals. You take their other insurance clause and you take our other insurance clause, and if they cancel each other out, they're co-primary. So the question you have to ask yourself is, respectfully, court, are the two policies purport to be excess of one another? We maintain very clearly that they do, because you have to, there's no ambiguity in the language. Our policy, their policy is excess. No doubt their policy is meant to be excess over another primary policy. But so is our policy. The Milmick policy says excess over any other coverage, any insurance or any other equivalent coverage.
Would you
This is
say-
other equivalent coverage.
HPIC is a true excess with respect to Milmet, because to
Correct.
be a true excess, rather than an other insurance clause, you have to identify the underlying policy, and it identifies Milmet. It doesn't identify Kaleida. So is it excess, could it be excess to Milmet but not Kaleida? No, does that bring HPIC into the payment game?
The Bovis case cited in our papers, Judge, I think addresses this question. A common misconception when you're dealing with other insurance clauses is this concept of other insurance versus the primary level insurances. So I would say under Bovis, cited in our papers and other cases that followed Bovis, if you're a true excess policy, in other words, you don't ever contemplate providing primary level coverage, then you're excess over all of the other primary policies. That's what HPIC is. HPIC says we're excess over everything. How can you tell that?
and
Because
if you-
HPIC doesn't have a, I'm sorry.
And we know they're true excess because they name at least one underlying primary policy, even if there might be others, you don't have to name the others.
I think the better way to describe that, if you follow Bovis, is they don't have a defense obligation. The hallmark of a primary policy is whether or not they trigger from the moment that they have to defend the case. HPIC doesn't. Kaleida does. And so does Milmet. Milmet's not saying, by the way, that we don't have any coverage obligations here. All we're saying is, look, your plan is a primary coverage. It's equivalent coverage that we're excess to. And we recognize that you're excess to us. So under Lemire versus State Farm, right? We're co-access, which basically means we apply ratably based on limits.
The two other insurance clauses cancel each other out, and we look at the policy limits, and unfortunately for Kaleida, they have more, so they got to pay what, 78% in your view?
That's exactly right. Under the E.E. Cruz case cited in our case, it's a ratable and that's the only issue I think. Frankly, the trial court wrote a 21-page decision here and did a pretty darn good job, right? They went line by line and they went point by point. The only issue that we have, I think trial court got this right too, conceptually. The only issue that we have with the trial court's decision is we have 1.3 in coverage, which is, by the way, exactly what he was required to have under the employment agreement. 1.3 per occurrence, 3.9 aggregate. They have a $10 million coverage, right? So our position is we have 1.3 in 10, so we pay 1.3 divided by 11.3, which is 88.5% of the risk, which is exactly what we were supposed to do. That's what Milmet wants the court to do. That's what the trial court did. And there's nothing in that trial court decision other than a math error by grabbing 3.9 from the aggregate as opposed to 1.3 from the occurrence limit or the claim limit. There's nothing in the trial court decision that's wrong. Why is it not wrong? I would tell you the hallmark of it is because it follows the contract. If you just follow the contract, it gives you the right answer. So we think it's fairly clear here. This is not a difficult case to decide, Your Honors. The trial court nailed it on all fours. He is a covered person. The claim was presented. They waived any late notice that they have. There's no prejudice. Mr. Neidl mentioned 100%. He's absolutely correct. There's no prejudice. They defended the case and showed up in open court, and Ms. Sweet admitted that they had been defending the case and they were cooperating. There was a big argument over whether Kaleida could have independent counsel. They got it, but they recognized and admitted they had responded ad superior because he was their employee. So from our perspective, if you follow the language and follow the policy, we are co-primary policies and we should pay 12.5% of this. 88.5% should fall on Kaleida. This is exactly what 11.5%, I suppose, exactly what was required in the employment agreement, and exactly what the two policies said. If any other questions, I'll sit down. Thank you for your attention.
Thank you. Case 488 is Bates versus Gannett. Right, we have the appellant counsel is virtual. We have them both on. So Ms. Sweeney, you may proceed. I'm sorry, Mr. Sweeney, I'm sorry. You may, there you go. Okay.
Okay, thank you very much, Your Honor.
Thank you for your patience, by the way.
I
with it.
learned a lot about all different subjects. That's part of the fun part of being here, watching an appellate court. I represent Rick Bates. Bates was illegally hired as a newspaper delivery boy by the Democratic Chronicle when he was 11 years old. He has pled before he reached the legal age of 12 that he was repeatedly sexually abused by Jack Lazaroff, the district manager of the Democratic Chronicle, who was negligently hired to supervise young boys, and the Democratic Chronicle utilized as child labor to deliver its newspapers. He has pled that the Democratic Chronicle, now owned by Gannett Newspapers, failed 11-year-old Rick Bates by the negligent hiring, attention, and supervision of Jack Lazaroff, who was later fired as a child sex abuser. 37 years later, Rick Bates was able to file suit against Gannett as a result of the enactment of the Child Victims Act. And if Gannett prevails in this appeal, this court presents the only opportunity for Rick Bates to state what had happened, what had been done to him in a New York court of law.
Counsel, could I ask you this question? If this happened today, I know that the CVA revived these old claims. So that's what's causing the issue here. And does the CVI bring up for review administrative claims and all that? But if this were to happen today, somebody in Mr. Bates' position would not be able to sue in civil court. The exclusive remedy would be workers' comp for a paper boy or for an employee who was sexually assaulted by a co-employee. Strange as that sounds, the case law seems to suggest that the exclusive remedy in that situation is workers' comp. Would you agree with that?
Yes.
Right. So your client, you're saying, should be able to go to civil court. Unless if it happens to somebody today, they can't. Your client 40, 50 years later can, because why? How is that?
Was the Child Victim Act is a specific statutory and device that has language in it that in essence revives the claim, notwithstanding any provision of law which imposes a period of limitations to the contrary.
So it not only does it revise the step of limitation, but it puts Mr. Bates in a better position than he would have been back in the day.
I believe that that's the case.
Okay.
And I think that the reason it's the case is because it's enacted to cover every civil claim or cause of action alleging negligence relating to sexual abuse of a child. It has very general language, but it applies to every civil action, but with someone who's done damage to a child. It also has limitations or limiting language in the statute on affirmative defenses that can be asserted. They allow you the affirmative defenses to be asserted under the penal code to the various sexual components of the Child Victims Act. It doesn't allow for a defendant to, in essence, avoid the statute of limitations that was revived by the legislature to shift them to another agency, which will then assert a new statute of limitations. It's not a trick here. It wasn't designed to make people think that they might have claims. It wasn't designed to pretend we're going to give you something and then pull it out from under you later on, 3 years into the litigation.
Yeah. I'm not sure the legislature contemplated a sexual assault claim by a fellow employee, but let me ask this. I should ask at the outset. This case was this is a stay. Judge Chimes stayed this proceeding so that the workers' comp board, with their expertise, can make a determination. That was 18 months ago. Do we have an answer from the board yet?
I don't believe that you do. I think that there is some activity that's going on, and they've begun to say that there was no claim that was filed back then. So it's coming back to a new statute of limitations.
So 18 months and we have no word from the board?
The board has not acted, is my understanding.
Okay.
And the initial decision as to whether or not the Child Victim Act requires them to do something could have been determined by the trial court. In other
Right.
words, all of the language that we're struggling with in our briefs, and I can see that both sides here, there's a conflict between the Child Victims Act and whatever the assertions are under the Workmen's Compensation Law. All of those issues could have been addressed by the trial court. She took the position that it's only up to the Workmen's Compensation Board to determine such things. They're never going to determine this.
We are equally, if not better equipped to resolve the questions that you're asking than the board, which deals with workers' comp issues.
Yes, and you're also
And
better.
Is it,
statutory,
it would seem like, let's say that workers' comp does apply, that the bar does apply, but it only applies if the employer has workers' compensation insurance. And I know there's a dispute where the paperboy's covered, but now there's no remedy in workers' comp because it would be time barred over there. So there's no remedy over there. So your argument is they should be able to pursue their civil claims in civil court because there's no possible way they can proceed over there.
And the statute says that despite the statutes of limitations that may be asserted, that every claim is to be determined by a court of law. He's entitled to a jury to hear his story. The reason I read the preamble, and I know the court has read it, this may be the only time that he gets to tell anyone what happened to him in a public forum. It's taken 5 years for us to get to this point. Part of it was because of COVID, but part of it was 3 years worth of discovery before they made the motion. We have a viable cause of action under the Child Victims Act, and it's only this distraction of the workman's compensation assertion that has stayed all of the discovery. If we had at least been able to continue with our discovery, they deposed our client, but we never got to depose their clients. They stopped us from proceeding with our litigation, and we're now 18 months into it and have lost that time. The problem with suing 2,000-year-old institutions or institutions who print ink, who pay for ink by the barrel, is that they can wear down the plaintiff like this. We've had a number of people who have died with these cases pending. 5 years is too long, and they're delaying our day in court because of it. What essentially is being dictated by Judge Time's decision is that the 12 and 13-year-old Rick Bates should have filed a claim in the Workmen's Compensation Board every time the man touched his genitals over a 1 year period. Every time that he put his mouth on Rick Bates's penis, he should have filed a Workmen's Compensation claim.
And then his benefits would have been, what was he getting wages back then? I was a paper boy. I don't know, $2 a week. He was like, here's your $20 for all this. Have a good life.
I was a paper boy too. We didn't get wages. And what we did get is they charged us, maybe we paid 4 cents for the Long Island Press and charged 5 cents. So they let us keep the penny, and most of the money we made was on the tips. And if the people were generous enough and you brought the newspapers without getting them wet, you had a better chance of making money. But
well, I just have one question. Are the paper boys, aren't they independent contractors? Are they employees subject to the Workers' Comp Board?
According to Gannett, and there's a Court of Appeals case, O'Rourke, which held that they were. But in that case, O'Rourke, there was a paper boy who, in the course of his route delivering his newspapers, he crossed a big intersection to get an ice cream cone or an ice cream, and he was hit by a car. That's the type of case that's appropriate for workman's compensation. This is not a workman's compensation case and never will be. It was always something that needed to be determined by a court of law. The Child Victim Act, being with its specific language of covering every claim and specific enumeration of the affirmative defenses that can be pled, the Child Victim Act is an unusual animal that I suspect is never going to be encountered by any of us again in the rest of our legal careers. Everything we do, we make new law on. Every issue, every motion, every claim becomes an issue de novo for the courts. And the courts have been extremely accommodating and liberal in interpreting this statute, that they allow that trying to put together a case 47 years later is an uphill battle. And instead of letting us pursue our case, they stopped us. And when we were stopped, we were ground to a halt is the ability to get discovery and the ability to get to the point where we can present to a jury our case. It's a travesty of justice, not from the fact that good lawyers and good courts can interpret things differently, but that it denied us the ability to move forward with our case.
Thank you, Mr. Sweeney.
Thank you, Your Honor.
Ms. Iacopelli?
Yes, that's correct. Thank you, Your Honor. I am not going to take up much of your time. I agree with everything that our co-counsel, Mr. Sweeney, has stated. And I will just briefly say that, this really isn't your typical slip and fall case. This is not a case that should be heard by the board. As Mr. Sweeney said, here we're dealing with 11 to 14-year-old boys who were sexually abused by their supervisor when they took a paperboy job to earn some extra cash. That sexual abuse included their supervisor touching and fondling their penises and genitals, engaging in oral sex with them, and masturbation. This isn't a worker that slipped on a banana peel in a grocery store and broke their hand. According to the respondent, though, simply receiving a paycheck as a paperboy would preclude these appellants from seeking or obtaining any remedies under the CVA and seeking justice in a court of law. They haven't, though, even pointed to a single word in the CVA or its legislative history to show that that's the case or that that's what the legislator intended, which it's not. Despite the clear legislative history on this case, though, as Mr. Sweeney pointed out, that it was intended to revive all civil claims, what the trial court did was basically punt this issue to the board to decide. In doing so, a stay has been in place, like Your Honor said, for 18 months. During that time, none of our clients can even attempt to get closure on this issue. And I just wanted to point out briefly this court's decision in LG 46 Doe v. Jackson, where this court actually reversed a stay of a CVA action and remanded the case back to the trial court for further proceedings. In doing so, this court stated that a further delay undermines the purpose of the CVA, which is to finally allow for justice for past and future survivors of child sexual abuse, help the public identify child predators through civil litigation discovery, and shift the significant and lasting costs of child sexual abuse to the responsible parties. And I would urge the court to do the same thing here. By continuing to allow the stay, we're not having that opportunity to pursue civil litigation discovery. We're not having that opportunity to allow our clients to discover the truth of what happened to them. And as Mr. Sweeney importantly said, our clients are now stripped of the right to have a jury of their peers hear their story. So I would urge this court to follow its decision in LG 46 Doe v. Jackson and likewise reverse the stay here.
If we were to vacate the stay, could we say to Judge Chimes, you shouldn't have stayed it. You need to rule on all of these issues. The issues being, does the CVA revive worker these types of claims as a worker? Those are the issues she did not resolve. She punted them, well, not punted them. She sent them to the board to resolve. Can we have her do that, or are you asking us to do it in the first instance?
I would say, Your Honor, that I am asking this court to do it. I think that it's right for this court's review, and I think that this is the proper forum to do it in.
Your clients have waited long enough.
They have waited long enough. And, I will tell you that having to deal with these clients, it takes a wear on them, and they're not getting any better, and their psychological injuries just continue to mount.
All right, thank you.
Thank you.
Ms. Hyatt.
Good morning, Tracy Hyatt on behalf of Respondent Gannett. I want to address your question first about where the status is with the Workers' Compensation Board. As Mr. Sweeney noted, there has been activity. Gannett took the liberty of filing all these claims on their own, which is unusual in the workers' compensation context. It usually comes from the claimant.
Well, you want to file them because there's really no money at the end of the rainbow there for the plaintiffs.
Well, also it was consistent with the judge's order.
Right,
so
yeah.
They needed to be filed. They weren't after a period of time. So Gannett took the liberty of doing it on their own through their insurance carrier. And the onus is now on the claimants to substantiate their injury. they've received notice that the board has these cases, that they've been filed, and they have not provided any documentation of injury for the board to even render a decision or a determination on these. So this has taken a very long time because the claimants or the plaintiffs in this case haven't provided any documentation to the board to show that they were injured. So the board can't render a decision.
Well, I thought the board was going to decide, are these claims properly before the board without getting into the evidence of.
My understanding is they can't even get to that point unless they have enough to substantiate there was an injury.
Okay.
So the board would then decide whether they were employed, whether the injuries took place in the course of conduct, whether these were revived potentially by the CBA, or whether these claims are outside of the workers' compensation benefit system. And I think the other point that you made initially about whether these could have properly been brought when they were employed in the 1970s and 1980s, these claims were not revived.
Wasn't it for the courts to determine whether or not it's appropriate for the Workers' Compensation Board to address these issues? Aren't the courts required to do this?
Well, the
It's a
workers'
question of law and not a question of whether or not it's injury or damages or whatever it might be.
I agree with that. And the Workmen's Compensation Law, Article 11, is very clear that the liability is assigned through the workmen's compensation system. And the CBA didn't address that, doesn't mention the workers' compensation law. And when the CBA is reviving these cases, it talks about periods of time that were imposed, as in statutes of limitations that were imposed. And that was the purpose of the CBA. It says it twice within the statute, and that's really clear within the statutory language. It's not ambiguous that the purpose of the statute was to revive untimely claims. These claims had a different basis of liability. The liability because these were employees, and we established that through in part the depositions, and it took a while to get to that point. And that's why the stay motion came after many months of litigation, because we needed to have that information. We needed to substantiate that there was coverage for the entirety of these periods of time, which spanned from 1979 to 1990. And as
These paper boys were, I know the workers' comp policies don't individually name people, they name classes of people, and they fell within the class. So your argument is if they sued timely back in the day, they would have been precluded. It would have gone to workers' comp. If they sued it today, they would be precluded. So it would be unjust. This is not what the CVA intended to do. It intended to revive claims, to put plaintiffs back in the positions they would have been if they had sued it timely, which wouldn't have led to civil court for that.
Exactly.
All right,
And
we understand.
And with these appellants in particular, it's the nature of the claims that they raised. They're suing their employer for negligence. And those claims belong at the Workers' Compensation Board because the employer in this case had workers' compensation insurance in place for the relevant time periods. The CBA is very clear about what it revived. It's matters that did not come within the right time period. And that's not what we have here. We have matters that, although they very well could be untimely, the liability that is assigned to these matters is to the Workers' Compensation Board. And the CBA did not change that. The other thing that I would note to this, because Mr. Sweeney did bring up that, and that these kinds of claims are unusual, perhaps for the Workers' Compensation Board when you're talking about sexual assault, but that's not true. The legislature has considered changing the workers' compensation, specifically the workers' compensation law, section 11, where it talks about exclusive liability falling to the board how it relates to sexual assault. And the legislature has declined to do that. So the legislature is aware that these sexual assault claims fall within the purview of the Workers' Compensation Board, and they have continued to assign exclusive jurisdiction to the Workers' Compensation Board. Justice Chimes, in her stay decision and stay order, considers all of these different factors, and she reaches a decision that there's enough to merit sending it to the board to make a determination on the questions of fact that still remain, and potentially the questions of mixed law and fact. And that's consistent with any of the case law coming out of the Court of Appeals, which O'Rourke, I know we all cited too, but also from this court, that when there are questions of fact, those are within the exclusive jurisdiction of the Workers' Compensation Board if you have employees alleging negligence and the employer has workers' compensation insurance in place for that time period.
Well, thank you.
Thank you.
Case 489 is BLO4 versus Fleming. McCarthy, good afternoon, good morning still. We've had a number of these Fleming cases this term, last term. I'm sure you are following them. Is a lot of the same issues here, but we'll let you get started with that understanding that we have wrestled with these. I don't think any of our decisions come out yet, but there's a whole lot of them in the queue.
Well, thank you for that, Your Honor, and I'll keep the factual recitation to a minimum because I know the court's heard it over and over again. I'm Ryan McCarthy of Ferrara Forenza on behalf of the Rochester City School District. The appeal in this case and the others that Your Honor mentioned is about notice to the school district and when we can get notice when there's an allegation by a plaintiff that a teacher is abusing a student. In this case, the school district met its burden with the court below. The plaintiff and all the other witnesses admitted they never reported any of the abuse while they were students, and the Fleming had generally positive reviews at the time he resigned. The big issue in the case is the application of CPLR 4549 to the statements of a former teacher, Moses Cofield. They're presented to the court as evidence in the form of a deposition testimony of Bieldo 5. The statements themselves do not mention Fleming by name. They do not mention sexual abuse. They do not mention any other corroborating evidence other than I know what's going on.
Well, weren't there two statements? There was one, I know what's going on, and then another statement when he has her over at Highland Park in his car, and he makes some statements there. Right there, do I have that right?
No, Your Honor. The full statement from her deposition transcript all happens at the same time. Okay. He picks her up after school, drives her from the school to Highland Park, presuming that they're going to go home. And she testified, when I got in the car, he said he wanted to show me a special place, and he ended up taking me to Highland Park by Reservoir or something. And at that time, he told me he knew what was going on.
Okay, what I meant to say is that there are statements where he is trying to perpetrate sexual abuse on her.
Correct.
And that'd be kind of ludicrous to say that those were within the scope of his employment, but the statement, I know what's going on, might be, could we look at that a little bit differently?
Well, it was in the same context. It was the statement is, I know what was going on, so you should be nice to me. And then he tried to kiss her. So they're not really separated in time or space or context for that matter, Your Honor. Okay. And you know, I think Your Honor mentioned that he wasn't operating within the scope of his employment when he made that statement. And that tracks with what the sponsoring memorandum for the statute when CPLR was enacted a year and a half ago or so. The federal rules, particularly the 11th Circuit and the District Court of Connecticut, which I mentioned in my brief, have kind of laid out what that line is where an employee's statement becomes admissible or not. In the Lesnick case, which was from Connecticut, admitted statements of an employee who wrote an email to her boss reporting on what she had seen. They found that that was an admissible statement because she was making this statement in the course of her duties. As Your Honor said, Mr. Cofield was certainly not operating within the course of his duties. He completely abandoned any loyalty he had to his employer when he was coercing that poor woman into kissing him in Highland Park. So for that reason, the statement does not fall within CPLR 4549. It's not an exception to hearsay, and it should not be considered by the court and with respect to the motion for summary judgment. The second point I'd like to make, which is different from the cases I believe the court has heard, relates to the cumulative evidence kind of presented in the lower court's decision here. The plaintiff in this case, Bieldo 4, was allegedly abused from about 1980 to 1981. Bieldo 5 had happened in the earlier 70s, and Bieldo 3 around the same time as well, a little bit later. The plaintiff here, again, admits that she never made any reports or said to anyone that she was in an inappropriate relationship or being abused by Mr. Fleming. However, plaintiff uses the statements of Bieldo 3, this Cofield statement, and some other deposition testimony of Bieldo 5 and Bieldo 1 to try to say that the district was on notice of Fleming's alleged propensity to abuse students. The way it's presented by plaintiff and from the court below, it seems to take all these separate pieces of information and cumulatively impute them on the district. We're asking the court to reject that analysis because there's no evidence that any of these school employees were aware of the other reports. Specifically, Bieldo 3 reported in her deposition testimony about 6 different times she said, I felt uncomfortable, or he gave me the creeps. Her memory, admittedly, in the deposition transcript wasn't clear, but giving her the benefit of the doubt, she made 6 different reports to 6 different teachers. Now, if she had made that same report or multiple reports to one principal, one teacher, maybe a red flag would come up. But in this case, they weren't made that way. And the statements themselves weren't specific enough to say to a teacher, oh, I think there might be something nefarious going on here. I think I need to bring this up the chain or investigate it. So for that reason, we think the court should not accept this God's eye view of the district's imputed knowledge that the plaintiff and the court below are asking.
Is that a question for the trier of fact to determine?
Well, I don't think so, Your Honor, unless you can find each one of the statements themselves were enough to establish notice.
That's whether or not they're going to be admissible, right?
I'm sorry, say that again.
Whether or not they're going to be admissible at trial for the jury or the trier of fact that can even consider.
Well, no, I think that the statements that BLDO3 allegedly made to her teachers, they're admissible. We're not saying they're hearsay. Well, there wasn't an affidavit in the record, but she did testify to those in her transcript. So those are admissible evidence. But whether or not they constitute notice, our argument is they do not. Applying the standard from Moran, which is the Court of Appeals case that is the seminal case on school notice, the Moran decision specifically mentions school authorities, meaning there's an implication that somebody has to be able to do something about it, this alleged posed danger to students, for the notice to be imputed on the district. And that just doesn't happen here. There isn't enough specificity in the statements for a teacher to say, I'm really concerned about BLDO3. We need to look into this further. We need to ask her what's going on. And the same thing with BLDO5 as well. At the last oral argument, which again, I won't hash again, she had multiple passes to get away from class, but there's no causal nexus between that and the alleged abuse. She testified she wasn't abused when she got those passes, and she gave a medical excuse when she was asked about it by another teacher. The last point I'll make is that the individual attention or the one-on-one sessions that Fleming may have had with BLDO1 or BLDO5 as a part of their music studies, it isn't a red flag or isn't something that shows that a teacher demonstrates a propensity to abuse students. Rather, it's kind of standard operating procedure for students to be given individual attention when they show an interest in a topic from a teacher who's the chair of that department, which is what happened in these cases. Nothing in and of themselves that is alleged by the plaintiffs shows that there's an inappropriate relationship or a crossing of boundaries by any of those statements made by the students. And with that, if there's any questions, I can.
Thank you, counsel. Mr. Bonsbach.
Thank you, Your Honor. Yes, back on April 8th, two of the cases were argued. The one case was from 1968 to 1970 when the sexual abuse by Fleming took place. The other case, the sexual abuse was during the 1972 to 74 school years. This case, BLDO4, that we're here on today, involves sexual abuse ending in 1981. That's 13 years after. And in that 13-year interval, there were numerous instances of both actual and constructive notice that were not referenced back on either of the cases that were argued. I believe Justices Lindley and Ogden were on that panel, that were not argued because they post-date what happened then. The Moses Cofield statement was one of the issues that was argued. That was the event when BLDO5 at West High School was picked up from a bus stop while she was waiting on Genesee Street to catch a bus home. The music teacher, Moses Cofield, stops and offers her a ride. She's not a he was an orchestral music teacher. She's not doesn't play an instrument, but she knows who he is. She takes the ride home and he says, let's go to my special place. And they get out and he tells her, I know what's going on in the back office of that music room. If you don't want it to come out, you should be nice to me. And that sounds like a jury question, as I know that the school district is contending that that's ambiguous. It's unclear what was meant. But I think a reasonable juror under those circumstances might have a different view of that. And that should be something that does go to a jury. But the irony here is that so Moses Cofield makes this threat to her. She isn't nice to him. He tries to kiss her. She runs away. And he still doesn't tell anybody. So in terms of actually abandoning or any harm coming to the school district, because as we know from Kirshner versus KPMG, the Court of Appeals case, for the presumption of imputation not to apply, two things have to be present. One, the agent's actually intended victim, it's kind of an awkward phrase, actually intended victim has to be the principal. And two, there has to be harm suffered by the principal. Harm is not a long-term thing, it's a short-term detriment. And further, the harm that comes to the principal can't result from the uncovering of the wrongful act. So here we have this Moses Cofield fellow who clearly is a disloyal employee. He's worse than disloyal. It's terrible that a school district would have had this person as an agent. But as Kirshner tells us, under principles of agency, who's in the best position to protect or to determine who its agents are going to be? And of course, restatement of agency talks about it's the principal, because they select this agent. They can train, they can mold this agent to be a good person and to do what they're supposed to do for the benefit of their principal. So with Moses Cofield, that doesn't happen. Let's talk about the imputation of what Moses Cofield knew, assuming that's a jury question. I know what's going on in the back office of the music room. You should be nice to me if you don't want it to come out. From an imputation standpoint, 4549 says that two things have to happen. And in our brief, I quoted right from the Unified Court System website where the judge's book, the evidence sections are. And to quote, it says that there's two things that are required. A statement offered against an opposing party shall not be excluded from evidence as hearsay if made by, subpart B, by the opposing party's agent or employee on a matter within the scope of that relationship, and, that's part one, during the existence of that relationship. So when Moses Cofield makes that statement, it's a statement about what happened inside West High School, one of the school district's buildings, concerning one teacher that he works with and a student that he has a duty to protect. When he says it at the park to her, I know what's going on, he's still talking to a student who happens to be someone he's supposed to be protecting. But the statement concerns a matter within the scope of that relationship. Moses Cofield's employment relationship. He should have gone with that statement and taken it to the principal or to some other school authority. He doesn't do that. And you can ask, and as I think we've asked, why didn't he do that? And partly it's because there's no policies, procedures, training. When someone identifies or has a suspicion that sexual abuse is taking place, what are you supposed to do with that? Okay. He doesn't know what to do, so he doesn't do anything other than to try to maybe use it for his own advantage. The second part of that test under 4549 is that during the employment of that relationship, well, Moses Cofield, when he says that, is an employee of the Rochester City School District. And the fact that he said it in a park, if he had said it in a grocery store, if he had said it to a stranger, it doesn't change that he made a statement that was within the scope, that's on a matter within the scope of his employment relationship. And it's while the time that he's an employee of the school district. So we don't think that that should matter at all. Moving on to other facts, though, that weren't argued back on April 8, because they weren't before the court because they're later in time. There's another teacher, Mr. McCarthy, talked about a God's eye view and how looking at these discrete pieces of information, no reasonable person could have, no reasonable parent or parent of ordinary prudence could have pieced them together. There's a second teacher at the school district who learns that Fleming has been sexually abusing someone, and that's Carol Watson. Carol Watson is another music teacher that works with Fleming. She works with Fleming at East High School, and she's coming back to the office in the music room when she sees the piano accompanist, a woman named Grace Trebert, now deceased, screaming at Fleming, having caught him fondling a student in one of the practice rooms. She stays around for a while. Carol Watson doesn't report it, but she says, and she testified to this, that Grace Trebert later tells her that she had reported it, and that Grace Trebert reported it to Elaine Frazier, who was the director of music for the entire city school district. There's nothing in any of the discovery showing that there's any acknowledgement of that report, but we have that as the testimony of Mrs. Watson.
And there's testimony from teachers or students that people refer to him as Flem the Feeler. Do I have that right?
You have that correct. So in 1970, the 78 school year, Carol Watson is teaching at West High School, which is where Fleming had taught up until June of 72. And when Carol Watson tells people, faculty members at West High School that she's going to East, she's being transferred, she stated in her, this is before the school district representative, but she identifies it as factually correct. She sends an email stating that when I told people that I was transferring to East High School, and I quote now, the constant reply I got was, This is my favorite part. Eek, you'll be working with Flem the Feeler. Now, Fleming hasn't even worked at West High School since 1972. We're now at the end of the 78 school year. So 6 years later, Fleming's reputation as Flem the Feeler still is there. So again, that would seem to suggest that, maybe this is something a parent of ordinary prudence might be interested in knowing what their daughter was going to be in a classroom with, particularly if they're going to be alone with him. So the Grace Trebert instance is proof that was not before this court back at the April 8th argument. Some of the other things that were before the court, for those that weren't on that panel, there's a photograph of Fleming taken in June of 1970 with a high school senior girl on his lap. Maybe you've seen that in the record. Fleming's testimony was, I never had any inappropriate physical contact with anyone. There's other testimony, again, after the two cases that were before the court on April 8th, that he had given piggyback rides to numerous girls in the school. Mrs. Watson, the music teacher, testifies that she said it was common to see him in the hallways with a girl on his back. She said the whole staff knew what was going on. One of the other students, Victoria Vasico, also remembered seeing Fleming giving piggyback rides at East High School when she was a student there. We also have the testimony that was not before the court on April 8th of Victoria Vasico, who's the only plaintiff that wanted her actual name to be used. Everyone else has a pseudonym. And Victoria says that Fleming would routinely give long hugs in the hallway. He would stroke girls. He would pet their hair. He would do things that I think you could say at least were creepy, perhaps were something more than just creepy, that certainly as a parent of ordinary prudence might have triggered, some sort of an inquiry. We think that Judge Schiano got it right when he went through a lot of reasoning. I know they argue that this God's eye view should apply. The school district shouldn't have had to piece things together. But the irony is they were specific instances. Moses Cofield knew. Terrell Watson knew. Other complaints were made from which you think they would have known, but they didn't. Nothing was done. With regard to the issue about supervision, one of the points in our brief, which was not addressed by Judge Schiano in the court below, was that the school district hasn't shown it did anything to supervise this plaintiff, or indeed any of the plaintiffs, or for that matter, that it did anything to supervise Fleming. And we believe, and there's a bunch of cases cited in our brief, that as a prima facie matter, the school district has a duty to show that they did some reasonable measure of supervision, both of the plaintiff and of the teacher. Absent that proof being in the record, and there is none, absent that proof, we never get to the issue of whether there was proper notice or not, because the school district first hasn't stated its prima facie case. Thank you.
Thank you, Mr. Bond.
Thank you.
By the way, the last case on the calendar was 491. We had it down for argument by the respondent, and we are told that is now submitted. So we are now done for the day. Thank you.
It's 490 over the term. 490 over the term.
Yeah.
And what about 491, 493.1?
That's what.
Oh.